रेडियो जिंदगी 92.3 FM HD2 पे वेलकम लिसनर्स वेलकम टू द शाह पिराली लॉ शो ब्रॉट टू यू बाय शाह पिराली लॉ ग्रुप. Attorney Shah Pirali is on air with us from now till 11 a.m. Attorney Shah Pirali is the founder, president and managing attorney of the Shah Pirali Law Group, which is headquartered right here in Newark, California. He is a member of the American Immigration Lawyers Association as well as the State Bar of California. He is a passionate advocate of human rights, civil rights, social action and social services, and he has a strong interest in and knowledge of the political and the legal system here in the U.S. He formed his law group to work on the causes that he feels most ardently about. His law group focuses on immigration law with an emphasis on employment-based immigration, and they help clients all over the U.S. They have offices in Newark, San Francisco, and also Washington, D.C. Listeners, if you'd like to ask Attorney Shah some question, if you'd like to get in touch with him, you could do so right now during the show. The studio lines are open and you can call us on 510-657-1170. That's 510-657-1170. Attorney Shah Pirali's office number is 510-742-5887. That's 510-742-5887. And the website is piralilaw.com. You can also call on the office number right now as we speak to make an appointment to talk to him later on. So let's get started. Let's see what Attorney Shah has in store for us today. Attorney Shah, good morning.
Good morning, Ara. Good morning to all the listeners. Again, this is Shah Pirali, and we are going to talk, of course, about immigration and maybe other social issues related to it. And before I start, of course, anything I'm telling you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. I hope you can hear me properly, right?
I can't hear you fine. No, I can hear you. We have a caller who's already holding to the line to speak to you. Let's take this call first. Hello, you're on air with Attorney Shah Pirali.
Yeah, go ahead. I'm listening.
Thank you for taking my call. Hi, sir. I had a question related to switching jobs while I-485 has already been filed. My priority date is April 2013. EB3 downgrade, I-140 was approved like 2 days back in the premium processing. And I'm joining a new employer in maybe a month time frame. I just wanted to know, is there any risk associated with switching? Can I file medicals with that 485J, and what do I need to ensure to make sure I don't screw up this case?
That's a very, very good question because I get it very often, especially right now. So, number one, yes, this is there is a possibility to switch jobs under 8021 Section 104C, if I'm not mistaken, section, and it allows you to move to a same or similar position if 180 days has passed. Usually I tell people not to move unless the I-140 is approved in case of downgrade, and this is your case. So that's another kind of, it's not a required, but it just makes things easy because in case your I-140 is not approved, kind of RFE, and you shift your job, RFE goes to the other company, it becomes a big mess. But in your case, yeah, it is okay to move. Just make sure you meet because the 180 days has passed probably. So just make sure you move to a same or similar position, and make sure you file the supplement J as soon as possible. Because the way the rule works, before they issue the green card, you can move. But once you get the green card, it's not recommended to move because then it gets into the issues when you go for your citizenship interview. So it's not unsafe to move. So when you move, quickly do your supplement J and then send the medical. Usually I recommend go ahead and do the supplement J, then send the medical. But right now they're asking people to send the medical as soon as possible. You can send it together. And that's it. That's all you have to do. And you need to send also a copy of the letter of job offer with the supplement J, just to be on the safe side. And make sure you describe, you meet the requirements of same or similar position. And that's where a lot of people get caught because oftentimes they don't prepare the paperwork right. Most of the time it goes through, by the way. There's no problem, but just make sure that that part is done properly. That's all.
Okay, so I can file medical while filing 485G together?
Well, usually wait for the RFE of the medical before sending it, but since they are recommending people to send it as soon as possible, you can send it together. But just make sure also you keep an extra copy or have your doctor ready in case they kind of, if the medical gets lost while they're processing your supplement J, then you can just get another copy from your doctor, sealed, and you send it again. Okay?
Got it. Okay, thank you so much. Thank you.
And good luck to you. And that's a very good question, by the way, because that's something that I get pretty much every 2 days, the same question. And one of the things I recommend when it comes to the same or similar position, talk to, if your attorneys are not familiar how it works, talk to an independent attorney to evaluate it. And you can call us if you need that help, like a second opinion, 510-742-5887. Okay?
So, sir, I had one last question related to this. My H1 is being transferred. Do you recommend 485 being filed before that, or should I wait until H1 is completely transferred, or those are two different things?
Those are two different things. You don't really need the H1 if you have your EAD. But
I haven't gotten it. Yeah.
Sorry, you didn't get your EAD yet?
No, not yet.
Okay, then.
My I-140 just got
your H1. So what I recommend is file the H1, get it approved, then move, because you don't have the EAD. Then you do the supplement J, because what happens if something goes wrong and you don't get the H1B approved, then if your other company you left them, they might just cancel everything, and then to go back to them, you'll have to do another supplement J to send it back to them. So it's not, it's two different things, but the most important part is, of course, your green card, right? So you want to keep that alive.
Got it. So you recommend like getting the H1 approved and then right away file 485J?
Then you move. Yeah, and as soon as you get the H1 approved, get them to file your supplement J while you're moving, because there's a chance that your green card will be issued soon. Okay?
So does it need to get approved until the new employer can take over the application, or is just a file that they just have to do? And then, because I don't know whether I get RFE in between while I'm doing 485J filing. What if I get RFE? Like, I'm confused about that also. Like in medical.
No, you can. You don't have to, because like I said, if you had an EAD, this problem will not be there. The problem will be, okay, let's put it like in more realistic terms. You're working with company A and you are moving to company B, right? Right now, if you had an EAD, this problem there will be no problem. It's just like shifting job while you have a green card. But in your case, since you're depending on the H-1B, what happens if you move to B and then B's H-1B gets denied, and then you already move the subject to B, then you want to go back to A, and A has canceled your H-1B, you will be in a tricky situation.
Yeah. So I'm not changing my employer until my H-1B is approved. The only question is that if I get medical RFE while they're filing 485J, those are two different.
The medical RFE, just hold it on until you get that H-1B approved, because they will give you some time to do the medical, unless there's an urgency. And if that's the case, then you give me a call. I'll guide you what to do next, because it's a case-by-case basis. There's no general answer in that situation. You just have to work the timing right. It's all about timing at this point.
Okay. So I don't have to wait 485J, right? Until 485J is approved before I submit the medical, right? I just have to make sure H1 is transferred before I submit the medical.
Yeah. The supplement J is usually gets approved most of the time, unless you miss that part of the same or similar, because you already meet the requirements of 180 days. That's a given. And the same and similar position is the only one that is left. So as long as this is done properly, just make sure you're done properly, because if you shoot a different job, completely different, you're going to have a problem because the supplement J will not get approved, and ultimately the I-485 will not get approved, which means you don't get the green card.
Oh, okay. So that's the only thing that I have to make sure. Okay, cool. Thank you, sir. I really.
Well, in your case, that's the only thing. For other people, they have other issues, but in your case, you already got the I-140 approved, and you already have the 180 days. So the only one to focus on is the same or similar position. Okay?
Oh, sounds good. Thank you, sir. Thank you so much.
Good luck to you. Thank you so much.
Thank you very much for calling in. The most important question that you had asked in the beginning was how to not screw this up. All of us really have to pay attention to that one. All of us, and thank you for calling. I'm going to drop that call now. And that's the most important question, and that is why we are also doing this show. That's why, listeners, we have Attorney Shah Pirali on air with us to tell you how to not screw up the case, especially it's USCIS immigration. I mean, that's the most crucial part. So thank you for asking that question, and Attorney Shah, thank you very much for going in detail with the answer. Listeners, if you also have any questions, call us right away on 510-657-1170. That's 510-657-1170. Any immigration related question you can call right now, be it about yourself, be it about somebody else, किसी friend का कोई situation चल रहा है, you can ask them to call us right now. You don't even have to tell us your name. You can just ask the question. 510-657-1170. Yes, Attorney Shah, let's get started.
Thank you so much. And indeed, I think I should change one now. How not to screw it up. There's so many ways to do that. And even lawyers sometimes, even with experience, sometimes you might mess up a case. Simple mistakes can cost people very deep. I've seen cases where people completely omit the big things, while some people, they do everything perfectly well, but then they're filing the wrong forms. Or they're filing something that is useless because they got something else. And that's why when I do a consultation, I always kind of take all the approach when I'm looking at the case. Someone might call me for an H-1B, but I will ask them questions. Have you ever been attacked? Have you ever been molested? Do you have this? Because all those options are on the table. And you might be trying to take the wrong route when you have a shorter route. I'll give you an example. I had a few years ago, I had a client calling, wanted to get an H-1B. Then I realized she had an I-140 approved and her dates were already current. I told her, well, this is a big company. Do they want to hire you again? She said, yeah. I said, well, we'll just file an adjustment of status with an EAD with that, and you can work on the EAD, and you'll get the green card too. And she asked me, is that possible? Because I left the country for so many years. I said, yes, you can. And ultimately, within 6 months, she got a green card, and she continued working with them, and they didn't have to worry about an H-1B. But she was kind of getting all stressed because the H-1B lottery was not open, and she never had an H-1B. She was on a J-1 or something like that. So it's a little bit that knowledge that people probably will call me for, and that's why the caller was saying they don't want to screw it up, but at the same time, you want to know all your other options. Don't limit yourself, and the knowledge of all those visas becomes very, very important, because people don't call me because of the law. Most of them know the law. What they call me on is usually to find a solution for them, right? And that's why when I talk to people, I ask several questions, and that's unfortunately what we cannot do on the radio on those short answers. So it's good to, if you want to analyze or basically kind of look for all the routes, you can call me at 510-742-5887. Yes, you are going to ask something like that?
No, I was in fact going to give out the office number, which you already did. Listeners, the office number for a direct call for getting in touch with Attorney Shapirali after the show. To make an appointment, you can call them on 510-742-5887. That's 510-742-5887. The website is piralilaw.com. That's PEERALLYLAW.com. This is still the H1 season. A lot of people's H1s got picked earlier, and then there were RFEs, and they were wondering what to do, like our caller as well. So, listeners, RFE is something that, requires a lot of attention. So, you need to do the things right and have an attorney by your side to tell you how to do it. Attorney Shah, tell me this thing. I mean, this is off topic maybe, but if, how everybody is working with organizations and they already have their attorneys, the organizations have their attorneys and law firms who are helping them with immigration, can somebody still consult with you and find out alternate ways?
Definitely. There's actually, I'll say three-quarter, or I'll say three-quarter, 75% of my consultations are for the second opinion. I have many people when they call me, they already have their company attorneys, and they want to make sure that the attorney knows that what they're doing is right. And I'll tell them up front, when the attorney is messing up, I'll tell them if they're messing up. And if the attorney is right, I'll tell you they're doing the right thing for you. There's nothing else you can do. But I can supplement this also. Sometimes the attorney is doing the right thing, but there might be other shortcuts based on my experience where I can kind of guide them. I tell them, okay, tell your attorney to do it this way, and it will work. And you'll be surprised how many times I do that, because I don't want people to kind of pay two attorneys at the same time. But if I can put my 2 cents in it, and 2 cents in it more than that, I'm more than glad to do it. And that's what most of my consultations are on. And it does, and there's no law that prevents you from having two attorneys. But I always recommend that to stick to one attorney who has their name on the case, but get the opinion of someone with experience who can kind of give you that little plus.
Absolutely.
That's
true.
Mm-hmm. Yes, go ahead.
No, but I was also going to ask you, I mean, since there are not a lot of immigration reforms happening at the moment, in this time, what are people mostly, calling you with? When people call you after the show, when they want to discuss these things with you, is it mostly these H1s and H4s, or is there anything else that also people want to ask you?
I get calls. I got a lot of calls, and that's the interesting part right now is, of course, this visa built-in, right? Everybody wants to know what happens next because the September visa built-in saw another jump of 6 months. But now there's something that is also coming up. There's a big chance we won't have more jumps now. We're going to see a steady growth, but it won't be more jumps like I was expecting, and that's something that has been that they have hinted that people should not expect a lot more now. So if in case your case can be downgraded to match the dates, go ahead and do it. But don't just downgrade it, what they're calling downgrading, right? That means moving from E to B3, for example, for India. Talk to an experienced lawyer who can guide you what to do next. Because I have a lot of people who call me in October, whether they do it or not, and they're very happy with the fact that I told them exactly how things are going to be and what are the risks, and luckily it pretty much is what has happened. And many people were actually happy because of the fact I told them, no, in this case you should downgrade. In other cases I said, don't downgrade, it won't be helpful for you. Okay. And that's the interesting part. Yes, go ahead.
No. I was just agreeing. You could keep continuing.
Okay, cool. So, the visa built-in is a big thing. And the question, surprisingly, our caller, when he called, the first caller calling about the situation, his situation of moving jobs, because now 6 months has passed and the AC-21 rules, you can move to a same or similar position. And it's always the same problem, like I mentioned to our previous caller, is that the biggest issue is to match that same or similar position. And this is not an easy task, by the way. A lot of people think, okay, you can just call the lawyer and they will. It takes time because we have not only to match the code, but also the main thing is the job description, especially if it is not the same position. For example, if you're moving as software engineer to software engineer, it's the same thing pretty much. You might be okay, but it's not the title, by the way. We're looking at the job description because a lot of people confuse title with job description.
Mm-hmm.
You might have all the title, but there's no job description matching. You're going to have a problem. So be careful on that part and make sure that your lawyer, most lawyers do a good job, by the way. There's no issue on it. But just make sure you yourself, you can do a match. And one of the good websites to use is flcdatacenter.com. It's the government Department of Labor website. That's the one we use for H-1Bs and also for green cards. It's flcdatacenter.com. So you can check it, put your state and your county. You can even check the wages, the prevailing wage, etc., etc. So that's the best website you can use to get that information. And that's what I'm getting a lot of questions on. And of course, non-employment based, the other thing I'm getting a lot of course, on are the U visas, because this is something that a lot of people don't even know about. A U visa for people who are victims of many crimes.
Attorney Shah, before we move on to a different category of visa, I wanted to ask you about these RFEs. Let's say there's an RFE and they need more documents about your some previous employer, maybe 2 employers ago or 3 employers ago, and now you cannot get hold of them for more documents or for supporting documents. What can be done then if you just cannot get hold of them? What should we tell USCIS, or should we produce some other document?
It depends exactly what is RFE. It's a very interesting question. When they're asking about a specific company stuff, most of the time the company will not provide that because many of them are confidential, even if the company didn't close down. Now, if the company closed down, then we have a bigger problem because if they are questioning the previous company, there might be an issue of fraud involved. And in this case, it becomes more complicated. One of the things you can do if you're not getting any documents, you can put a declaration in the case stating that you tried to the best of your abilities to get the company, but you couldn't get it. But everything depends on what kind of questions, because if they're going very specific, usually they will not ask you those questions, but they can. They're going very specific. That means the previous company had a problem. For example, let's say you got an I-140 approved, and you're using the priority date, and you file a new I-140, and they come back and they send you a notice of intent to revoke, which means they're revoking the previous I-140, and they're asking a lot of questions. In this case, then right there, there's a chance that this previous company has been charged of fraud, or they have been investigating the company and they have found that there was something fishy going on. Mm-hmm. And if that's the case, then you not only lose the previous I-140, you also lose what we call the priority. So this is something on a case-by-case basis. But when they ask RFEs on a specific company and they're not asking it from the company, then you have to be ready that something is not right in the case. And in this case, you might want to talk to an experienced attorney before you make any move, because at this point they're already investigating something.
Okay, all right. So even if it's just for documents, there might be some kind of investigation involved. So one has to be careful.
No. If it is a simple document, they will say, hey, we want a letter of recommendation, we want a letter of experience or something like that. That's not a problem.
So that's what I'm saying.
Right.
Any document they want from any employer, and if you cannot get hold of them, so can you just tell USCIS that you can't reach them, and this is how much I tried? Because people, honestly, we panic.
Yeah, there are many ways to deal with that. One of the ways I've dealt with it is, for example, H-1B people need experience letters, and the company is not willing to give. So what you can use, for example, is your contract that they made you sign at the when you started working with them, where the job description is mentioned, and you can put a declaration explaining that you're not able to get any other documents from them. But it becomes very weak when you can't do that, because oftentimes they are expecting you, when you leave a company, to get a recommendation letter where you have all this. But most states don't have any laws that force them to give you that letter, remember. So that's another problem that a lot of people face. But most people are experienced with it, so they go ahead whenever they leave, they try to get that letter. Even if it's not a recommendation letter, at least a job description. And if not, then we can use H-1B or any kinds of contracts to prove that. Or sometimes you can even get another colleague who was working with you to write something, an affidavit stating that, okay, I know so-and-so person, and they have worked in this capacity, and ultimately they worked on this and that.
Attorney Shah, we have a caller who would like to speak to you. Let's take this call.
Sure.
Hello, you're on air with Attorney Shah Pirali.
Hi, I have a question for Attorney Pirali.
Sure.
We were trying to get a H-1B visa appointment in India, but it is showing like on the website, like not available, and one is showing even in January or February for H-1B visa. That one, if we are clicking it, it is saying, sorry, not available. So are you aware of this type of error or what is going on?
No, your first time I'm hearing that, actually. There might be glitches that are coming. I know people are getting appointments, but some of them, I never heard of when you click on the system, it's saying not available. What might have happened is that you saw the date and someone else at the same time just click on that date. It's just like eBay when you buy something, right? You think you got it for that price, you're bidding, and someone else is bidding there, and it just went before you. And that's what probably happened. But usually the system is pretty good. But
because it is showing,
I have not heard of it.
The first availability is showing in January, and even that one we are clicking, then it is showing that, sorry, now not available or some error.
Yeah, someone will probably took it just in front of you, but the system has not registered on the screen, but in their internal system, they already took the date. Or there's a glitch on the system, which I have not heard, actually. You're the first person telling me that. Maybe if other callers are hearing you and the same thing is happening, let us know, but I will check on it.
Yeah, it is so weird that, first of all, there is no appointment showing in October, November, September, and August even, and nothing like we were trying from so long. And one opening, and even not in February or March, even just showing one opening in January, and that one we are clicking, and it is showing 9 appointments available.
When did you try? Did you try again after that?
Yeah, so many times, twice a day or something.
Really? Wow. Well,
so it's looks like some CDI website, like whatever they have, the visa one, and there it's showing like this is the error. So I was thinking maybe you are aware of it or you have some information.
No,
like you're getting from other callers.
But this is the thing. If all the dates are booked around February to March, then the January kind of is not really normal that they have a date available. So it's probably a computer glitch reading it also. And, it's kind of doesn't really make kind of sense, right? If till March the book, how come a January date is still available? So I think
so in that case, can we inform somewhere or do something about it or no?
Not that I know of, unfortunately. You can write to the go online and write to the U.S. Embassy in India. Which embassy?
Yeah, U.S. Embassy in India.
Okay. So, you know which one?
Which location?
Delhi,
location?
Delhi, even any places,
Delhi, okay.
Delhi, Hyderabad, Kolkata, anywhere it's showing, each and every places it's showing. We are changing the location even also, but it is showing it's still the same error.
Could it be happening that maybe they are not giving out those appointments at the moment and it's only for emergency work because of the COVID situation?
Yeah, so that's fine, but you know, as I said, in January only 31st of January, and that also, it is showing couple of times at 11 o'clock, 4 appointment, 3 o'clock, 9 appointment, and something 2 o'clock, 6 appointment. So at least that one, at least it should get picked. But when we are pressing that one, even for that also, it is showing, sorry, not available. So weird, and where to inform what to do in that case, because H1 time is October, right?
So many weird things have been happening lately. It's not. Remember, we are not in normal times right now. Everything is a mess. But I will try to find out if more people this is happening.
Yes,
but
please. I really appreciate it. Yeah.
Yeah, no problem. But I cannot, because these are more like technical issues. So we'll try to find out.
Right.
Yeah, they will try to publish it, and I will let you know if I find out. Okay?
Sure. Thank you so much. I really appreciate it.
Thank you so much.
Thanks. Bye-bye.
And thank you so much. And hopefully, last minute, luckily,
so
we might have a finish.
So if got selected for H1B, then it should be any time to get a visa, or it can go up to January. I heard, or I know that it can be by they should come here.
No, you can come up later. As long as the job is still there, you can come up. You can come by, no problem. Okay?
Okay. Thanks.
Okay. Good luck to you. Take care.
Thank you for calling in, Attorney Shah. We have Attorney Sharif on air with us, and we also have a caller who's on hold.
Okay, let's take the caller. Sharif, hi, assalamu alaikum. Give me 1 minute. We'll take the call and then we'll continue. Yes.
Hello, you're on air with Attorney Shah Pirali and Attorney Sharif.
Hello. Hey, Shah. I have one question regarding my downgrade EB2 to EB3 I-140. So my question is I filed this downgrade I-140 last year in October 2020. And so far it's been about 10 months, which is outside of USCIS processing time. And so wanted to check and my priority date is September 2012. So I wanted to know is it a good idea right now after waiting so long to do it in premium processing for I-140?
Yes. Yeah. Do it in premium. Because there's no purpose to wait now. It's been so long. And if they start processing the cases, you might want to do that, because there's a big chance we're going to see a retrogression coming soon. I don't think it will go up to 2012, but it will come. So go ahead and do your premium if you're eligible. Okay?
Okay, I see. So is it, the question is how USCIS will process the application? Do they process based on the receipt date when the AOS and this downgrade was submitted, or they process based on the priority date? For example, if someone has filed this AOS before me, but their priority date is after, for me, it's September 2012, and someone has a 2013 priority date, but if they have submitted adjustment of status and I-140 before my application, so how does this get processed?
So it's always the priority date first, and then the second is the processing date. So if someone has
I'm not able to hear you clearly. Your voice is coming out very low.
Yeah, what I'm saying is that it's always the priority date first, and then the second is a processing time. Okay?
Okay, always the priority date is first.
Yeah, but right now you have to understand there's a big mess up, so it might go the other way. But usually that's the rule.
Okay. I see. So for regular I-140 processing, isn't it since we have waited for this long, is there any possibility to get it processed in like maybe next few weeks or couple of months or so?
Yeah, it is possible, but I don't think so because they don't have enough people to process it. That's all. It's all about the number of people working there. Unfortunately, that's a problem. They're overwhelmed there.
I see.
Okay. Good luck to you. Let me take Sharif now.
Thank you. Thank you very much for calling in.
Thank you.
Listeners, if you also have any questions, you can call us right away on the studio number 510-657-1170510, 657-1170. And the number to call, the office number to call is 510-742-5887. That's the office number for Shah Pirali Law Group. You can get more information on the website piralilaw.com. That's PEERALLYLAW.com. Yes, Attorney Shah and then Attorney Sharif.
Yes, Sharif. How are you?
Attorney, I think one thing to just chime in on the last caller, I find it quite stunning that one, is in a visa backlog for almost 10 years and, has their date current, was able to file a downgrade to I-140 adjustment of status, and then is hesitant to file premium processing. I mean, that to me is a little bit, I don't want to, kind of insult his intelligence, but I think that is not a very prudent approach. I mean, you're possibly sacrificing your entire life future because, as you had mentioned, I mean, it might not go back to 2012, but I mean, if it retrogresses, I mean, he's going to feel really, really dumb at that point.
Yeah. Well, one of the reasons they don't file is the cost, and many people also, and then they're scared of RFEs, and then also many companies don't want to spend the money. So it's usually the cost. So I recommend people it's better to spend the money, like you said. You waited so long. Why would you just wait more when you get a chance to do premium? Because many people didn't know they could do premium. So now they can do. They should do it. That's something, and that brings us. You really entered the conversation really at the right time because one of the things we were discussing now, I think we're not going to see any jump anymore that next month, right? And we might be seeing even a retrogression, right?
Exactly, because I think they're really surprised by the large number of downgrades from EB2 to EB3, and the data, has now become available to the State Department from USCIS, and this is really going to throw the numbers off, in a dramatic way. So, they've already announced that there's going to be no advancements in the visa bulletin for the first part of the 2022 fiscal year, which starts in October 1st. So we know for sure there's going to be no advancements. But, whether it retrogresses is going to be interesting. I mean, we hope it does not, and that would be a really, shame. But definitely, there's not going to be a situation where there's going to be much advancement absent some, congressional action, which, again, is not really clear.
Very doubtful. They're not very interested in really doing anything on this. And that's what brings us to really the point now. People gave up a lot on the EB1, thinking they can go on the EB3. And if there's a retrogression, unfortunately, people will be able to keep their EADs, but they might end up waiting a long time like it happened in 2007 until they get a green card. But the EB1 is a way out. So tell us a little bit about this, Sharif.
Yeah, I mean, I think as particularly for anyone that, has been kind of waiting for around 5 years or so, if your priority date is around 2015, it's not likely without some intervention that there's going to be an opportunity, even if you're 2014 at this point, for anything to really change as it relates to the processing of your green card. So, we really, really need to look at, an all of the above approach and make sure that you're putting yourself in a position to succeed. So what we have been doing for our clients, and including people that have dates have become current for EB3, is that when their EB1A I-140 is approved, we do an interfiling, and then their basically their existing already submitted I-485 adjustment of status is upgraded to processing under an EB-1A criteria where, it's no longer tied to the employer. You don't need an I-485 supplement J, and, things are generally fast-tracked from that point. So, there's a huge, huge benefit for folks who have done this, and as you know, we've been very successful with, all kinds of cases. So when I look at an EB-1A scenario, I think one of the main things we're looking at is whether there is something in the individual's profile that can be presented as an original contribution of major significance to their field of endeavor. And this really takes a great deal of analysis and, concentration, because if you break that down, it's a really huge undertaking, right? Because, let's just think about it, right? There's originality, like original contribution. So you have to prove that you are the original creator or designer, or, they use the word contributor, but you have to kind of think of what is the verb, what is the action word that fits what you have done. So, for example, if you've taken something that already exists and made it better, that would not generally come under this criteria. But, for example, we've done a lot of cases for individuals who are DBAs, database administrators, and what they have done is they've created a completely new database to replace a legacy system. That would be considered an original contribution because it's something new that did not previously exist, and they are responsible for creating it. Then the question becomes, is this something that is significant within the field of endeavor? Now, that will depend on how do you define your field, right? Because some people, and I seen an individual not too long ago where his case was filed by a different law firm. I'm not going to name who did it, but they basically mentioned his field of endeavor as software engineering. It could have been software architecture. And that is really a ridiculous statement. I mean, how can one be responsible for an original contribution of major significance within the field of software architecture? I mean, maybe like you're talking about Bill Gates or something at that point. So that is the kind of failed analysis that many folks are doing. What you have to do is you have to narrow down your field to fit the specific area that you're working in. That way, your original contribution. So, for example, if we're talking about a database administrator, maybe your field would be, optimization of, databases for healthcare organizations. That is your field. So instead of saying your field is, software, you've narrowed that down quite significantly, such that you can demonstrate that you have original work that is of major significance. So how do we determine if something is of major significance, right? Because in the past, people used to say, well, I need to have, a published article, and that published article requires, citations. Well, that's true if you are a researcher. But if you are an individual who is, in the professional world, let's say an IT role, then the question is going to be the contribution that you are claiming, how is it significant to your field? What is the measurement of that, right? And the measurement in those cases will be, number one, whether you've made impact on subsequent work in your field, meaning how have other folks in the field been influenced or benefited from your contribution. So someone else who maybe is at a different company says, well, I really learned a great deal from so-and-so's contribution, and I was able to implement some of his methodologies within my own product creation process and was therefore able to make, XYZ contribution. And my XYZ contribution would not have been possible without his ABC contribution, meaning the ABC, the first contribution, impacted subsequent work. Someone else within your field was influenced by your work. So that is kind of a factor in determining whether something is significant. Another factor is whether there's widespread discussion about your contribution. Now, this is why proving originality is so important. So if, for example, we prove that you are the original contributor, you created a particular, let's say, you launched a new database for, Kaiser Permanente, for example, right? Completely hypothetical situation. The question becomes, was there any discussion when Kaiser launched this new database? Like, did Kaiser maybe make a press release saying, Kaiser launched its, patient portal 2.0 today, and this will store all of the patients, medical records and allow them access to it and request in a, timely fashion, right? So this new optimized patient database that has been released by Kaiser, you have proof that you are one of the original contributors to that database, and then Kaiser has made a press release, and then maybe it's picked up in other magazines or journals or newspapers or what have you. So that becomes widespread discussion about the contribution. Now, that press release or the articles may not discuss you and your name. They might only be talking about the actual database that was released. Well, that's fine, because you have your own internal documentation that proves that you were the original contributor. Therefore, we are able to, present that. And I think, this is a foundational area within an EB1A case, is to demonstrate original contribution and major significance. In fact, I think it's the criteria are not created equally. I mean, people are always trying to, join, for example, in reviewing and judging work in different kinds of, forums that are just, you pay to become a reviewer. The officers aren't stupid. I mean, they know they could read through that stuff. So you want to show that your actual life's work is what you're putting up front. It's not that you're doing these, side actions, here and there that will, prove one way or another whether you are an individual that has, demonstrated a specific criteria. Because in the end of the day, the question is whether the criteria demonstrates that you are recognized in your field as having expertise. So that is why, particularly if we're talking about people who are in, technology-related roles, the original contribution to major significance, critical role for an organization that has distinguished reputation, high salary, these are, in my view, the three most important criteria. And then we can look at the other ones.
Exactly. And like you said, you want to be a big fish in a small tank, and that's what we've been doing, kind of reducing the size of the tank. But at the same time, there are myths around. We have to break them, because people tend to read all those forums, and which is fine because a lot of information out there, but a lot of wrong information. Like when I tell clients, hey, you might qualify for an EB1A, but I don't have any publications. My lawyer told me I can't get it. So this is something that people don't know. It's just having publications doesn't make it more likely to get an EB1A or not, right? So tell us a little bit about that, Sharif, because that's the first question I get all the time.
100%. And I think there's also a differentiation between you have to understand that there's two criteria where, at least two criteria where publication may be relevant. And oftentimes people say, oh, you have to have at least, 300 citation or something like that. Well, that may be the case if you want your article to be considered as an original contribution of major significance to your field. But then there's another criteria that just says, have you authored published material? And there the requirement is that the authorship of the work was intended for a learned audience. Therefore, it does not really matter, whether you have a large amount of citation or not, because you're not submitting it as a significant major work. So if you have authored something and it's not really, a huge amount of citation, it can still be beneficial in your case. But it should not be the centerpiece of your case, right? It should be something that
exactly.
is, just kind of, helping and supporting it, but not quite the, front and center major, accomplishment that you have made. Therefore, whether you have an authorship of an article or not, it really is not the major factor in determining if you are, an EB1A caliber applicant, unless you are like a researcher, right? Like if you're a scientific researcher and that's your job, then yeah, I think authorship of published article becomes very relevant. But if your job is to design, automation solutions for shade controls, then honestly, we don't give a damn about your authorship of article. We want to know whether you've designed automation products that have been deployed in the field and have made an economic impact that other companies have taken note of, that have been discussed, that have been reviewed in different forms. So we don't care at that point about articles. So, I mean, that would be my analysis with regard to that. Now, if you happen to also have written an article about your, contributions or products or automation work, great. That's wonderful. We can look at it and but I want to focus on what you spend all of your time and energy and brain power and thoughts on. I don't want to focus on what you've done in the last 2 months to make a, supposed kind of, evidence that's going to help your meet a specific criteria. Again, I always assume that the government knows what it's doing in reviewing these petitions. I don't assume that they're dummies that are just going to, rubber stamp whatever, evidence is submitted.
Yeah. Thank you so much, Sharif. I think we're going to the close of the show, and I thank you so much. Hopefully we can do another show soon.
Absolutely. Thank you. And it's always a pleasure.
Okay. And take care of yourself, and take to all the listeners. Thank you, Ira. Anything we told you today is our. You should not ask your refrain to act solely on information provided.
Thank you so much, Attorney Shah.
Thank you.
Thank you very much for being here with us, and thank you, listeners, for tuning in. Remember, you can now call the office number also 510-742-5887 for more information and for making an appointment to speak to Attorney Shah or Attorney Sharif later on. And also the website is peerallylaw.com. That's PEERALLYLAW.com. Stay tuned to Radio Zindagi.